I'm happy to be competing against you today. So, best of luck. Or thanks.
Good luck to you, my friend.
Alright guys, 2 minutes. And we're gonna start. Let's get ready sooner. We gotta get going.
I don't want to like just like random. It also
But yeah, that's
sorry, I don't know what I'm saying.
You're always so time goes out, you finish the sentence, you kind of the point is not like 30 seconds.
Right down for the she doesn't want to see Alright, so
Alright guys.
I think we could use this. I think we could use this in our favor.
Here, Micah. Just go ahead and pray really quickly with each other before we start.
stock issues and just bring up any arguments and evidence we can and help the other, just help to good debate and learning opportunity and just help us to, whether we win or lose, just to have a really good debate and have a good time.
Are the judges ready? I'm ready. Negative team ready?
Yes, we're ready.
All right. Good afternoon. My partner, Victoria Solano, and I, Christopher Solano, stand firmly resolved that the United States federal government should establish new legislation to protect copyrighted material from infringement by internet plagiarism. Observation 1, definitions. Allow me to define some terms of our debate. U.S. federal government. The system of government as defined in the Constitution, which is based on the separation of powers among three branches, the executive, legislative, and judicial, from the Oxford Learner's Dictionaries. Establish. To institute something such as a law permanently by enactment or agreement. New. Having recently come into existence. Legislation. the exercise of the power and function of making rules, such as laws that have the force of authority by virtue of their promulgation by an official organ of state or other organization. Protect, to maintain the status or integrity of especially through financial or legal guarantees. Copyright, the exclusive legal right to reproduce, publish, sell, or distribute the matter and form of something. Infringement, an encroachment or trespass on a right or privilege. And plagiarize, to steal and pass off the ideas or words of another as one's own, or to use another's production without crediting the source. And all the ones except for the federal government have come from Merriam-Webster's Dictionary.com. Observation 2, harms or inherency. 1, you cannot sue without a license. The status quo does not allow individuals to take action against infringers who plagiarize their work. This is a problem because currently all material that an individual creates has the same rights as a copyrighted work. You cannot take civil action without a copyright license. According to the United States Copyright Office, they say, quote, no civil action for infringement of the copyright in any United States work shall be instituted until pre-registration or registration of the copyright claim has been made in accordance with this title. Harm 2, copyright penalties are too large. According to Kent State University Information Services, they say, quote, anyone found liable for civil copyright infringement may be ordered to pay either actual damages or statutory damages affixed at not less than $750 and not more than $30,000 per work infringed. For willful infringement, a court may award up to $150,000 per work infringed. And harm 3, court costs and process is long and expensive. Infringement claims hard to press for the working class. The Copyright Alliance says more than 2 million hardworking artists in the United States rely on the U.S. Copyright Office to protect their livelihoods. For too long, our legal system skewed in favor of low-volume, high-value industries. But for many of independent artists, whose claims of infringement often total a few $1,000s, it is far too expensive to sue in federal court, essentially forcing creators to forfeit their rights. Observation 3 plan. Our mandate is to establish a law allowing individuals who do not possess a copyright license to press civil charges in court on the grounds of copyright infringement. The second mandate goes hand in hand with the first. The second mandate is the formal copyright small claims court. Enforcement. The United States federal government, agency, United States Copyright Office, the funding, the U.S. government, and fees from other court cases. And the time enacted, the bill shall be enacted immediately upon casting of the affirmative ballot. And solvency. Our plan will solve the issue of internet plagiarism in the United States. Copyright small claims legislation. The Copyright Alliance says, the copyright small claims will provide a simple, quick, and less expensive form for copyright owners to enforce their intellectual property. The majority of copyright owners that are affected by piracy and theft are independent creators with small copyright infringement claims. The second mandate is currently being studied by the United States Copyright Office. Therefore, establishing this legislation will be a smoother, well-researched process. Observation 4, advantages. It controls the copyright infringement. Our plan is to establish a copyright small claims court that takes small claims of plagiarism and resolves them with reduced cap on damages. This court is desirable for the majority of Americans because it does not have the high costs and extensive process of a traditional court. The Copyright Alliance said on October 4th, Representatives Hakeem Jeffries, Democrat from New York, and Tom Marino, Republican from Pennsylvania, introduced the Copyright Alternative in Small Claims Enforcement Case Act of 2017. The legislation creates a voluntary small claims board within the Copyright Office that will provide copyright owners with an alternative to the expense process of bringing infringement claims in federal court. And advantage 2, it is more affordable and accessible. Copyright small claims court and the advantages. From Michael Zane, quote, the copyright small claims process is designed to be simplified and limit or eliminate the need for expensive legal fees. Judges, I urge you to vote in favor of the affirmative ballot as I now stand ready for cross-examination.
It's time to be ready. Judge ready? All right. Is the current copyright system necessarily weak?
I would say no.
You would say no. All righty. How many people are approximated to be affected by this plan?
I would say everybody who has been wrongfully accused of plagiarism or people that have intentionally plagiarized so that it may be stopped from further spreading.
Do you have a statistic for how many people are affected?
I do not.
Okay. What is the minimum cost of court registration for a copyright claim?
According to LegalZoom, I know that over $100 at least for a license, and in some cases it could cost as much as $30,000.
30,000. Okay. Thank you. Has this plan ever been put into use in a different instance? Has it ever been tested before? My apologies.
According to my recollection, I cannot remember any other time where this plan has been enacted.
And shall the government be incorporated into this plan?
Yes, they shall.
Okay. No further questions?
We'll let you know how much.
Okay. We'll just-
A minute, please.
Alright, are my timers ready? Are the judges ready? Alright. We stand firmly with my partner, Michael Smith, and Master Dugan, stand firmly resolved that the U.S. federal government should not establish new legislation to protect copyrighted material from infringement by internet plagiarism. Today, I'm going to talk about the problems with the affirmative plan. We're going to start with this. The affirmative team stated that our current system is not weak. It is not weak. Therefore, if it's not weak, why does it need fixing? Copyright infringement cases have declined by 22% in the last year. This claim is supported by the following evidence. Written by the track reports, it says copyright infringement fell 22% in 2016. New federal lawsuits over issues of copyright infringement fell 22% last year. Case-by-case court records compiled and analyzed by the Transactional Records Access Clearinghouse at Syracuse University found a total of 3,944 new federal copyright infringement cases were filed in the U.S. District Courts during fiscal year 2016, which ended September 30. This is down from the peak level of 5,042 such suits filed during the fiscal year 2015. While these two districts were standouts in both the volume and growth of their litigation in this area, all the other 9 districts that had at least 200 copyright infringement cases during 2015 saw their litigation numbers fall during 2016. For example, New Jersey had the 3rd highest volume of cases in 2015, saw its numbers drop precipitously from 423 new filings during 2015 to only 181 in 2016. Similarly, 4th ranked in Illinois and 5th in Maryland also saw their copyright infringement volumes drop in 2016. So this is addressing the significance issue. If our system is already working, why do we need, we do not need new legislation. The system will work itself out and they will continue to be dropping. And if plagiarism is not illegal, since plagiarism is not illegal, it makes it wrong to try someone in court for it. And so letting people go to court for things would create or for being sued for small copyrights they did not have to pay license for would create chaos, as many would try to claim something is their original work in order to gain money, even by winning a court case or blackmailing and threatening someone to sue them. And if people did not have to pay for licenses, people would not value their work as much, and they would not put as much time into it than if they would have to pay to get a license for it. Their plan does not address what if someone was unfairly sued for accidental plagiarism. Would people go to court and sue someone even if they had accidentally plagiarized? And then so those are just a few of the reasons that we see are wrong with the affirmative plan, and we hope you vote for negative.
Oh, you still have to context.
Ready for crossing?
So that should be Christopher.
Alrighty, you ready? Do you have any evidence for any other years that the copyright infringement cases have gone down?
Yes.
You might have to hold on.
Yes. You can please.
Actually, I have it.
And earlier you said that the copyright holders will value their work more if they have to buy a license.
Yes, because they would put more effort into it if they had to pay a lot of money for a copyright license.
Okay, and that is all the questions I have.
We would like to use prep time, just tell us in 30 seconds.
No, just big as that. No. Are you speaking? Yes.
30 seconds. used.
Good afternoon. I would like to say that the affirmative team stands resolved that the U.S. federal government should establish new legislation to protect copyrighted material from infringement by internet plagiarism. To begin, our plan was actually recommended by Jonathan Bailey, the author and creator of the site Plagiarism Today. He holds a very good standing in this topic because he has been studying the copyright law and cases for over 10 years. To address what the negative said in their constructive, that the system is not weak, why does it need fixing? Well, while the system might not necessarily be weak, it's definitely not being enforced by the majority of Americans who are being infringed upon. To give you some examples of how many people are being infringed, there is from Representative Jeffries, who actually introduced a bill that is basically our entire plan. He says, the majority of copyright owners that are affected by piracy and theft are independent creators with small copyright claims. More than 2 million hardworking artists in the United States rely on the Copyright Office to protect their livelihoods. 2 million Americans are being infringed upon, and unfortunately they don't have the means, the money to be able to go to court and alert the authorities that they are being infringed upon and they might be losing money from these people who are plagiarizing their material. Plagiarism is not necessarily illegal, but plagiarism is definitely a problem in the United States, and that's what we are trying to fix through this Copyright Claims Board. This claims board would be run by a group of certified attorneys and lawyers who are trained in copyright law, and they would go over cases that the people bring and would consider all the usual circumstances. However, there would be a minimum cap on damages, so that way normal people like us would be able to afford the cost of the court process and be able to get their money back if they have lost any. I would like to remind the judges that our plan would control infringement by letting people go to court and sue the infringers for their work or money that was lost. And this is more affordable and accessible for the majority of Americans. I have no further evidence. I urge you to vote for the affirmative ballot, and I stand ready for cross-examination.
Can I have or switch on camera ready? Can I just have a copy if you want to see?
Yes, you may.
Is your plan mainly based off the evidence of one person?
No, it actually comes from several sources.
If a bill has been passed, is it old legislation?
No, it hasn't been passed yet, but it has been
No, like
introduced.
if a bill in general is passed, is it old legislation?
No, because it hasn't been made into new legislation.
Has your bill been passed in any state?
No. It's only been presented to Congress.
And is plagiarism going down?
Is plagiarism, are the instances of plagiarism going down, are you saying?
Yes.
According to your evidence from 2016 it was, but the 2017 hasn't been observed.
My turn. Right. I think grab.
You
30 seconds, please.
have to wait 5 seconds.
What?
You've used it.
30 more. Can you remind me of 30 more? Judge ready? Timekeeper ready? All right. Good afternoon. My name is Micah Smith, and my partner and I, Kira Dugan, believe that the U.S. federal government should not establish new legislation to protect copyrighted material from infringement by internet plagiarism. Now, I would like to address the fact that the Affirmative team has stated that the government shall be involved in the enforcement and application of this plan. And we would like to argue that the government has proven to be ill-equipped to make logical and even moral decisions. Even more so, if our problem is decreasing as of 2016. May I have that? As of 2016, we have seen a 22% decline in new federal lawsuits over issues of copyright infringement fell 22% in the last year. This was authored in 2016. Case-by-case court records compiled and analyzed at Syracuse University found that copyright infringement cases during the year of 2015 saw their litigation numbers fall during the year of 2016, and we have seen a decrease since then. All right? So now, even more so, if our problem is decreasing as we speak, why would we want to further involve the government? As we have seen, they have been ill-equipped to provide logical and even moral solutions to our problems in the past. This plan is not only insignificant, because we're literally arguing for something that is taking care of itself. But I'd also like to mention that the copyright registration is not expensive to begin with. A minimum cost, according to the Copyright Office, the website at the Copyright Office, a minimum of $35 on online registration is applicable, and that is the minimum cost. And a minimum cost shall provide a sense of priority, causing people to consider the true significance of their problems. This shall free up the law so that they may address more pressing matters. A necessary cost naturally causes deeper consideration as to the benefit of a certain matter, therefore the value leading to more relevant and important cases taking the forefront and less relevant taking the back. There are also 350 million plus Americans as of 2016, and according to the statistic by Syracuse, there have only been 3,944 copyright infringement cases as of 2016. And as we have stated before, there has been a decline since then. Let's see here. I think that's all I have to say. And they're ready for cross-examination.
Yeah, Victoria, go that way. I'm gonna get super confused otherwise.
Okay.
Good afternoon.
Good
Oh, wait,
afternoon.
how am I judged if you're right? Good afternoon. How are you doing tonight?
I'm fine. Thank you.
All right. Can I please see your evidence for the Syracuse statistics?
May I have that again, please? There you go.
All right. Thank you. And I have no further questions.
Thank you.
With the negative, like,
Should I bring up the
minutes remaining.
Okay. 3 minutes remaining.
3 minutes remaining.
I'm just going to do this.
One minute used.
Is my timer and my judges ready? Alright, then I'll begin. We're going to argue inherency in the affirmative plan under their, I think it was their second harm. Copyright penalties are too large. We think it is inherent because, as we have showed in previous evidence, it is a reasonable fee of like $35 for a copyright, and so copyright penalties are not too large. If someone really values their work, they are going to pay the price to protect it. We are also going to argue in the Bill of Rights, the 7th Amendment, it states that in suits of common law where the value in controversy shall exceed $20, the right of trial by jury shall be preserved, and no fact tried by a jury shall be otherwise re-examined in any court of the United States other than according to the rules of common law. When the Bill of Rights was written, $20 was a lot of money to them. So basically, they made this law in order to eliminate petty, not as important cases, to reserve the right for more important cases. And if we gave everyone trials for small things like being able to sue without a copyright license, then we would be making much more important cases wait or require more lawyers, making trial costs go up for everyone, and therefore eliminating the opportunity for people who have significantly been wronged the affordability of a good lawyer and a timely trial. And then we're also going to argue solvency. Their plan has never been tried. They're arguing that they will implement all these things when they have not proven that it is needed, that the current legislation is already working. They have not proved that it is not working and that they need this new legislation. And that is all I have to say.
How much time do we have left?
You have 3 minutes 15 seconds.
Okay, we'll take 1 minute and 15 seconds.
So just, if you can let me stop shooting. Oh, gosh, I forgot to do this.
30 seconds used. One minute used.
team timekeeper ready? Negative team ready?
Yes.
All right. According to Track, which is Transactional Records Access Clearinghouse, which is the same website that the negative team had their statistic about copyright infringement cases falling. The same Track said, quote, however, despite these recent declines, the volume of new copyright infringement cases is currently still much higher than it was back in 2010 when filings began to climb. Currently in 2016, we're at the same, end quote. Currently in 2016, we're at the same amount of copyright infringement cases as we were in 2014. Also, the negative team said that many people are not being protected by their copyright cases. And we say, according to Republican Lou, he says, quote, more than 2 million hardworking artists in the United States rely on the U.S. Copyright Office to protect their livelihood. Also, in 2000, sorry, one second. The negative said that our plan and our reasons for this plan is not significant and petty, but small copyright owners can't defend themselves alone. And licenses are difficult to obtain, the negative said they're not difficult to obtain, but we say they are because you need a license for every single item you have copyright. And by Michael Zhang, he's a photography enthusiast entrepreneur. He says, quote, vast majority of copyright infringements valued at $3,000 or less, and the majority of intellectual property lawyers wouldn't take an infringement case without a potential payout of less than $30,000. This means that the small copyright owners can't defend themselves, and that is why we have a need for our plan. I thank you. I urge you to vote for the affirmative ballot.
Okay, how much time do we have left?
You have a minute and 58.
Okay, I'll take all that time for Brett, please.
Used.
All righty. Is the judge ready? Timekeeper ready? Affirmative team ready? All right. So, in our closing statement, I would like to bring back up the Syracuse piece of evidence that was currently addressed by the affirmative team. And I would like to continue on to read the article, as we believe it was taken out of context. Kicking off, however, despite these recent declines, the volume of new copyright infringement cases is still currently much higher than it was back in 2010 when fillings began to climb. These longer-term trends are shown in Figure 1. There's a graph if they would like to see it. This rise has been fueled by the growth of the internet as well as advances in technology. So this is not random increasing in numbers. This made it easier to both legally distribute digital content as well as to pirate copyrighted material. Large numbers of copyright infringement lawsuits were filed, for example, against music fans who use peer-to-peer technology to share music, so-called copyright trolls, parties that acquire copyrights to make money through the aggressive filing of cases alleged copyright infringement, often with little intent to actually produce or license the works. or a further source of litigation. It's my hands. All right. It goes on to say that aside from 2 districts, all the other 9 districts in question here that had at least 200 copyright infringement cases during the year of 2015 saw their litigation numbers fall during the year of 2016. And our opponents stated earlier that 200 artists rely heavily on the copyright infringement. And might I point out, the 200 artists out of 350,000 plus US citizens is not a significant number. This should not be taken into question. Also, they say that people cannot afford to pay for a court license. And might I say to that if it is really that important to them, they will come up with the money. If you break your leg, you'll find the money. If you break your arm, you'll find a way to repair your arm. I'm pretty sure of that. Now, for our closing statement, I would like to say that by the affirmative team's own admission, we have no weak system. And in fact, we have seen data to prove that we have seen a decline in copyright infringement cases over the course of an entire year. The copyright system, in truth, is working. Their plan is not solvent, inherent, or significant. They have no proof that it will solve the problem. And I believe that is all I have to say. Thank you.
Would the affirmative like to address that?
Yes, please, the rest.
2 minutes.
My judges and time for ready. All right. All right. I'd like to address what the negative said about saying that the article about copyright infringement cases was taken out of context. Because I'd like to say that in the actual portion that I read, quote, "The rise has been fueled by the growth of the internet as well as advances in technology. This made it easier to both to legally distribute digital content as well as to pirate copyrighted material." These two sentences just show how much more we need this copyright claims board, because with the more advances in technology, the more plagiarism that is plagiarism is easier to come across. And also for the statistic that the 22% has 22% of cases, 22% of the cases have fallen. They didn't include the increase from 2010 to 2015. In fact, it went from 2,000 cases up to 5,000, whereas the decline they talked about only drops it to about 4,000. So it's still at an all-time high. The Copyright Claims Board wouldn't necessarily take place in front of other cases in court because it would be its own separate court. It wouldn't be taking the time of lawyers, like they said, or the judges with these small claims because it's already going to a smaller court that's focusing on that. According to Chris Reed, quote, this bill comes on the heels of a big push by advocacy organizations representing the interests of individual creators such as the American Society of Media Photographers and the Professional Photographers of America to develop such legislation to give independent rights owners a meaningful opportunity to enforce their copyright interests. So this helps everyone in the middle class. The negative said that it was 200 people that were affected by this, but what we actually said, according to the Copyright Alliance that was quoting Representative Liu, more than 2 million hardworking artists in the U.S. are affected. Not 200, 2 million. And that is a big number. To read the rest of the quote, for too long, our legal system skewed in favor of low-volume, high-value industries. But for many independent artists whose claims of infringement often total to a few $1,000s, this is far too expensive to sue in federal court, essentially forcing creators to forfeit their rights. In conclusion, I urge you to vote in favor of the affirmative ballot. By legislating a small copyright claims board and allowing individuals to go to court when their work is infringed upon, we will significantly reduce the instances of plagiarism in the United States. Thank you for your time.
I just want to say again, you guys just blew it out of the water. That was awesome. And for not planning to be on the teams with the people you were on teams with, I'd be proud of you anyways. But knowing that that's the case, I honestly don't think I could have told if I didn't know what was going on. So really understand how great a job you guys did. I'm very proud of you. All right, but now I'm going to kick you out. While we decide.
Whenever we're to debate again, I know to get the medium lemonade because of Oh, like what else I found so funny is that when it was like this high, Victoria's like.
Okay, by a close 4-3 decision, the affirmative won today. You guys did awesome. As I said, it was I don't know, I always got relieved when I saw my ballots and saw that I at least had a couple people who voted for me, so it was a split decision. You guys all did very, very well. You worked together well, debated very well. So, really fast, because it's 3:15 already. I'm gonna go over just some quick personal things, ways to go. So, Christopher, obviously in the plan it was organized. You guys did a good job with your plan. But also in your rebuttal, I think you did a great job staying organized, making your points and moving on. Even though you didn't, I think labeling them would make it even clearer. But I still felt like I could, sometimes when people talk, they just kind of talk and it feels like a page-long paragraph in your head, and it didn't feel like that. It still felt chunked into pieces that were more manageable. And you had great eye contact. Kira, in your 1NC, you had a great overview to kind of just let you know where we were going. It was simple and straightforward, but necessary and needed and very helpful. And also good organization. And I really appreciated you naming the stock issues when you addressed them. That was super helpful when we were determining the round. I had them written down and underlined and you could just go, okay, there we go, there they are. So that was really helpful. Probably it's just something to work on would be just kind of take a deep breath. You just felt a little bit tense. You didn't talk nearly as fast as you have before. I was really proud of you. So very good job. Well done. Victoria. Again, all of you guys stayed very well organized. It was just easy for me to flow and connect the arguments because you stayed organized. And I feel like just all of you, that was a step above where you guys have been before. It was way easier to follow your arguments. I think you have a really good, persuasive, easy to listen to way of speaking. Something that they put on a speech ballot is building rapport with the audience. And I think you do that really well, kind of building a connection. People like, oh yeah, I want to listen to you. So I appreciate that. Let's see. Probably something to work on would be, let's see, I think just, naming those arguments, getting more specific. I think as I told Kaya earlier, it just takes it to that next level when the judge, you're basically telling the judge what to write down. I've heard people literally tell the judge what to write down, and that's not a good idea. But, as much as possible, break it down for them. And I think that would strengthen the way that you speak. Micah, again, I'm just very impressed. You spoke very well, clearly, smoothly. In cross-examination, I'm trying to think again, just, that was where I noticed the most tenseness, or tension, that's the word I'm looking for. So just try and, again, just relax and keep the focus on the judge so that it's more of a conversation with the judge that kind of includes your opponent. If you think of it that way, that can help to kind of diffuse tension there. So, last thing for everyone, please, no one ever again say, that's all I have to say. Never, ever, okay? Like, I think I will fine you or something in LD if you say that. Because I just, you were so professional and well-spoken, and then all of a sudden it was like, that's all I have to say. You're like, wait, I thought I could trust you. I thought you were, someone I could believe in, and then it just kind of like, poof, undoes a lot of what you just did in your speech. So, a couple speeches, it happened with a, okay, and for those reasons, or, say it creatively, but as long as you end with a strong stance. That's why, those are my reasons. I stand firm, as opposed to, I guess that's all I have to say, so I'll sit down because I wasn't really prepared to finish. That it totally flips the experience and the way the judge perceives you. So, I'm seriously considering finding anyone who does that. So, start practicing something new to say. But overall, very, very well done. Everybody, I'm so proud of you. Today was, and you just jumped right in and had a great attitude, and I'm just really couldn't have asked for anything better.
All is not lost.
All right, so we're gonna go clean up our rooms, read Gorgias at home. So I will add that to the email, read Gorgias for this week at home.
All right. How are you?
I just threw everything in.
Huh? I wasn't? Oh. Well, that's unfortunate. For the record, so just